When you think of Canada's justice system, you probably picture a global leader, right? A real model for the rule of law. But what's hiding behind that shiny reputation is a surprising and, frankly, a growing crisis that's hitting millions of ordinary people. So today, we're going to dig into the massive gap between how the world sees Canada's legal system and the reality for people on the ground. These words from former Chief Justice Beverly McLaughlin really set the stakes here. This isn't just about administrative issues or how high legal fees are. No, this goes way deeper. It's about something fundamental, whether the public actually trusts that the system is there for everyone. Because when that trust starts to fade, the entire foundation of the rule of law begins to crack. And this right here, this really just lays out the central paradox we're talking about. Look, on the world stage, Canada is a star performer, top 10 for rule of law. But when you ask its own citizens, well, the numbers tell a totally different story. 52nd when it comes to being able to afford and access justice, and 64th for freedom from discrimination. So what you have is this huge disconnect between the system's reputation and how it actually works for the very people it's supposed to serve. So, what's behind that disconnect? The easy answer is always, oh, it's just too expensive. But honestly, the problem is so much deeper and more tangled than that. So let's peel back the layers and take a look at the real barriers that people are slamming into. First off, let's just talk about the sheer scale of this. This is not a niche problem. Nearly half, 48%, of all Canadian adults will run into at least one serious legal problem in any given 3-year window. This isn't happening to some small, unlucky minority. We're talking about a widespread national experience. And we're not talking about dramatic, high-stakes criminal trials here. The most common legal problems are the kind of things that can happen to any of us: a dispute with a phone company, serious struggles with debt, or major issues at your job. These are often called justiciable problems, basically everyday life issues that could be sorted out by the legal system, but usually they're not. They are the absolute core of this crisis. Which, of course, brings us to the big, obvious question. If almost half the population is dealing with these problems, why aren't they all just picking up the phone and calling a lawyer? Well, the answer, it turns out, is really complicated. And maybe the best way to understand it is to picture a series of giant walls blocking the path to justice. There are basically 4 massive walls that people hit. First up, the most obvious one, the cost wall. Legal help is just flat out too expensive for most people. Second is what we can call the perception wall. A lot of people don't even see their problem as a legal one to begin with. Third is the complexity wall. The system itself is this bewildering maze of forms and rules that's almost impossible to get through on your own. And finally, there's the systemic harm wall. For many, especially people from marginalized communities, the justice system isn't a safe place to get help. It's a source of pain and trauma. Let's really drill down on that cost wall for a second. In Ontario, for instance, to even qualify for legal aid, a single person has to make less than about $19,000 a year. But just 1 hour with a brand new lawyer costs over $200. This creates this giant justice gap for the middle class. You're considered too rich to get help, but you're absolutely nowhere near wealthy enough to actually afford a lawyer. And then there's that second wall, perception. This one's really fascinating. Research shows that when someone has a dispute with their landlord or they're getting chased by debt collectors, they often don't think, I have a legal problem. They think it's a life problem, a money problem, a streak of bad luck. And if you don't define your problem as legal, the idea of hiring a lawyer, it just never even comes up. So, all of this brings up a huge question. If the system is this broken for so many people, whose job is it to fix it? Does this fall on the government? Is it their constitutional duty? Or does the legal profession itself, the people who have a monopoly on the system, have a special obligation to make sure the public can actually use it? Well, the Supreme Court of Canada has actually drawn some pretty clear lines here. On one hand, the Constitution does not guarantee everyone a lawyer for civil cases, things like contract disputes or family matters. But, on the other hand, the state must make sure the courts themselves are accessible. They can't set up financial roadblocks like massive court fees that basically lock the courthouse doors for everyday people. Okay, so what about the legal profession? Well, there are 3 key arguments that they have a special duty here. The first is vocation, the idea that being a lawyer is a public calling, not just another job. The second is trusteeship. Society gives lawyers a monopoly on legal services, and the trade-off is that they have to act as guardians or trustees of the system. And finally, there's the market failure argument, that the legal market is just plain broken, which gives lawyers a moral duty to step up and help people who are falling through the cracks.
Okay, so we've laid out the problem, we've explored who might be responsible. So, what's the solution? How do we actually fix this? Let's take a look at the proposed roadmap for reform and some of the biggest ideas on the table right now.
So, a major report from the Action Committee on Access to Justice laid out this really clear vision. The main goal is a massive shift from a reactive system that's like an emergency room to one that's focused on prevention and education. That means making legal services way more available, turning courthouses into user-friendly service hubs, using technology to simplify everything, and importantly, making access to justice a core part of what it means to be a lawyer. But, and this is a really big but, is that vision enough? Legal scholar Patricia Hughes offers this powerful reality check. She warns that these generic solutions, even though they mean well, can end up creating a kind of symbolic access. Yeah, it might look good on paper, but it risks leaving the most vulnerable people, the ones facing multiple overlapping barriers, still stuck on the outside looking in. And this really gets us to the core tension in this whole debate, the push to make the system more efficient versus the need to make it truly equitable. So let's look at some innovative ideas trying to solve this. And then let's end with one last really critical question. So, what do these innovative models actually look like? Well, in British Columbia, they're exploring having regulated non-lawyers who can provide specific legal services at a much lower cost. In the US, you've got legal incubators that help new law school grads start affordable practices for middle-income folks. And this idea of unbundling services is really picking up steam. That's where you hire a lawyer for just one specific task, like drafting a single document, instead of the whole expensive case. It makes legal help available in smaller, more affordable chunks. And all of this brings us to our final, crucial question. All these reforms, the new technology, the non-lawyer providers, the simpler processes, they're all designed to make the system more efficient. But is a more efficient system automatically a more just one? And in our rush to make everything faster and cheaper, what essential parts of justice itself might we risk losing along the way?